Very warm welcome to all. Today, I, Reeya Khanna, a legal intern under Lexis and Company, am here to explain my topic, Impact of Social Media in the Law of Evidence. This particular video is part 2 of this topic. In part 1 of this video, we understood the introduction that I gave relating to social media, how it is important in a human's life in today's time, and how misusing of social media leads to cybercrime and various other crimes. Further, I explained the importance of Information Technology Act in today's India. Later, I explained admissibility of social media as evidence, where I gave two case laws, where one, the case law was where the admissibility was recognized, and in the other case law, the admissibility was not recognized. Let us talk about how to determine the authenticity of these messages. In India, law enforcement identifies a suspect and then asks platforms to supply information about them. The evidentiary value of an electronic record totally depends upon its quality. Provisions regarding dealing with the evidentiary value of the electronic records are discussed in the Indian Evidence Act. Discussions on the authenticity and admissibility of documentary evidence in the form of an electronic record and its standards as par with the conventional form of documents are dealt with in the Indian Evidence Act. The evidentiary value of electronic records is widely discussed under Section 65A and 65B of the Evidence Act. Section 65B of Indian Evidence Act lays down the conditions and procedure of proof of an electronic record in a court of law. Section 65B is important as it recognizes that the original primary evidence of electronic record cannot be expected to be brought before the court, and even if it is, the same being in binary form, the same cannot be understood by court. The net effect of Section B is that the output in the form of a printout or data copied on CD or DVD, etc., produced by the computer is rendered admissible in the court, provided certain conditions are met. This is the impact of Section 65B Clause 1. The output of an electronic record, in order to be admissible in a court of law, has to be filed along with a certificate under Section 65B Clause 4 of the Evidence Act. Such a certificate has to be issued by a person occupying a responsible position with respect to the computer from which the data is produced. The certificate has to satisfy the conditions laid down in Section 65B Clause 2 relating to the integrity of data and the computer system. The manner of production of the output of electronic record, identity, and particulars of device used, including the original device. The entire idea behind the certificate is to ensure once again the integrity of source, the authenticity of data, so that the court can place reliance on it. This is important since electronic data is more prone to tampering and alteration. In the case, to quote a particular case, in Kundan Singh versus the state in 2015, the court stated that a certificate under Section 65B can be filed even thereafter and need not to be filed alongside. Now, let us talk about Section 22A. Section 22A has been inserted into the Indian Evidence Act to provide for the relevancy of oral evidence regarding the contents of the electronic records. It provides that the oral submissions regarding the contents of electronic records are not relevant unless the genuineness of the electronic records are produced in the question. Section 59 of the Evidence Act is amended by the IT Act 2000 to exclude electronic records and inserted Section 65A and Section 65B instead of submitting electronic records to the test of secondary evidence as contained in Section 63 and 65. Section 65A has given the right to prove the contents of electronic records in accordance with the provisions of Section 65B. Section 65A of the Evidence Act is for electronic records, just as Section 61 is for documentary evidence. Section 65A is a special law that stands apart from the documentary evidence procedure in Section 63 and 65, and any probative information stored or transmitted in the digital form is digital evidence or the electronic evidence. Now, that is all for this particular video. Let us conclude this topic by saying that the rules framed for investigation of digital evidence are sort of regressive and do not inspire much confidence when it comes to safeguarding the privacy. Digital evidence has proved to be a crucial role in the conviction or acquittal of a suspect in recent years. It is not just the Indian judiciary, but nations worldwide acknowledge the presence and the power of social media. Thank you so much.